on the launch of a publication on the impact of the United Nations human rights treaties on the domestic level. My name is Abigail Nuku. I'm the regional representative for the Office of the High Commissioner for Human Rights here in Southern Africa, and I will be your moderator today. I wish to begin by extending a warm welcome to all participants that have joined this webinar for the launch of the second revised edition of the book on the impact of the United Nations human rights treaties on the domestic level. We're focusing today on Egypt, Senegal, South Africa, and Zambia. This webinar is co-hosted by the United Nations Human Rights Office and the Center for Human Rights at the University of Pretoria, with whom we have enjoyed a good partnership for many years, and I wish to thank them for taking this initiative. We are grateful to our panelists who are also contributors to this important book for taking the time from their busy schedules to be with us. I will introduce them shortly. But the important question today is, why are we here? Well, as you are well aware, the United Nations treaty system, As you are well aware, the United Nations treaty body system is a pillar of the international human rights protection system. And yet, as our former High Commissioner notes in the foreword of the book, far too little is known about its impact and how it permeates to people through states. So this book seeks to respond to the simple question: what has the impact of the UN Human Rights Treaty system been, and what data exists to support the argument that the treaty system has been impactful? It has been a Herculean task on the part of its contributors and the editors, Prof. Frans Viljoen, Rachel Murray, and the late Christof Heyns. And we owe them a great deal for documenting this important work. But this book is also a tribute and a reflection of the legacy of a prolific human rights advocate, Prof. Christof Heyns, a man of great stature and might, both in his scholarly works and his genuine belief in the value of the international human rights system. Prof. Heyns pioneered the initial study, and in fact, at the time of his passing, he was on sabbatical working on this study. Whilst we miss him dearly, we also salute him and thank him for the innumerable ways in which he continues to inspire us. So we are grateful also to Frans and Rachel for bringing this important work to finality. So without further ado, I would like to call upon Professor Frans Viljoen from the Center for Human Rights to introduce himself and say a few welcome remarks. Frans, over to you.
Thank you very much, Abigail, and good day to all of you online. Thank you so much for joining us. Thank you very much to the Regional Office for Southern Africa, for the Office of the High Commissioner for Human Rights, for joining forces with the Center in hosting this event. This is the book. It's quite a volume. It's quite a doorstopper, as you know the phrase goes. We are really fortunate to do a series of launches of this book. There are 20 chapters in the book, 20 countries that are being covered. And today, as Abigail mentioned, we focus on those African countries. So of the 5 United Nations regions, we chose 4 countries from each of those regions to paint some form of a representative picture of the impact of the UN human rights treaties. Now, as was mentioned, there was a book that covered the terrain, as it were, until the turn of the century, the first 20 years, in a sense, that we focused on. The book, this revised edition, now covers 20 years subsequently. In other words, since 2000 until 2020, more or less. So clearly, so much had happened in the human rights landscape in these 20-year period that had eventuated, that one would expect a different outcome, as it were, in terms of the study. And that is, I suppose, what we will focus on today. We've seen an increase in the number of treaty bodies, and obviously treaties, particularly the ones on persons with disabilities, enforced disappearance. And we have seen also, very importantly, alongside the treaty bodies, the emergence in importance of the UPR, the Universal Periodic Review process. So that actually made our endeavor also more complicated, because it is certainly difficult to look at the treaty bodies in a sense and the impact that they have in isolation from the broader picture and the evolution of human rights across the board. I want to say that in terms of the title of the book, it talks to the impact of the United Nations human rights treaties. Clearly, we look at the treaties, but also at the treaty bodies. And in a sense, we unpack impact as direct impact, impact in a sense that is the product of the implementation of the treaty provisions, but also of the treaty bodies' concluding observations and views. So direct impact would be the material, observable influences that the treaty bodies, the treaties have exerted at the domestic level. But we also take heed of the importance of looking at impact much more broadly as a form of influence that is not necessarily directly relatable to treaty bodies' directives. This kind of impact is much more symbolic, as we term it in the book, and interesting forms of this impact would also then be the reframing of human rights discourses that have been important, the use of terms that are also changed over time because of the influence of the system, and even efficiencies that are much more improved at the domestic level. For example, we see the development of statistical analyses, statistical record keeping, because so many of the treaty bodies insist on that kind of information being available. We see the systemic influence also across the board in terms of the various thematic concerns of treaties. So just to give you that sense of how we understand the concept of impact, and then also just to say that in terms of the methodology, clearly our researchers are based in the countries, and they have looked at the primary materials. They've done an analytical analysis of the text, the primary text at their disposal, but they've also engaged in interviews to understand how officials, members of civil society, lawyers have also experienced this influence of the treaty body system. So with those few remarks, Abigail, I hand back to you and look forward to our discussion also involving our audience virtually. Thank you so much.
Thank you so much, Frans, for setting the scene really for our discussion and our webinar today. Taking us through this long more than 50-year history of the UN Human Rights Treaty system, how it has grown, how it has changed, but still the important question being, what is its impact? And I'm hoping that our discussion today will get us much closer to understanding what truly has been the impact at the domestic level. So during this webinar, as Prof. Viljoen has already alluded to, the authors of the chapters of the 4 countries will present a summary of their findings. They will highlight examples of the meaningful impact of the UN human rights treaties and discuss the challenges and opportunities experienced by these countries. We will have a maximum of 1 hour and 30 minutes for this webinar. So we're aiming to finish by 12:30 South Africa time. I will start by giving each panelist 8 to 10 minutes to present findings from each of the 4 countries. I will then open the floor to questions and comments and invite panelists to respond as appropriate. We would kindly ask all participants to keep their cameras off, and for panelists when they're speaking to switch on their cameras. We will then conclude with closing remarks and concluding observations, if you like, from the panelists, as well as from Prof. Viljoen as well, who will close our session today. So with that, and without further ado, I would like to check if our first panelist is ready to speak on the case study of Zambia. O'Brien Kaba, are you in the room? Are you able to take the floor? I am
I'm
not.
here, yes.
Oh, thank you. Wonderful, Brian. So I would just like to start by introducing Brian to everybody, and then I will give you the floor. So O'Brien Kaba is a lecturer in the Department of Public Law, Assistant Dean Research in the School of Law in the University of Zambia, and a Senior Research Fellow at the Southern African Institute for Policy and Research. O'Brien holds a diploma in philosophy from St. Augustine Catholic Philosophical College. He is an associate editor of the Southern African Institute for Policy and Research Case Review Journal. Prior to joining academia, O'Brien worked in Development Corporation. His teaching subjects currently are constitutional law, jurisprudence, international humanitarian law, and legal process. O'Brien, we are so grateful to have you. And since O'Brien needs to leave a little bit earlier before the end of the session, we would encourage you, all of the participants, to pose questions in the chat while he's speaking, so we can maybe give him an opportunity to respond before he has to go. But with that said, O'Brien, I would love to hand it over to you to make your presentation.
Thanks very much. I'm truly honored to be part of this panel discussion, and also to be part of the group that put up together this publication. Thanks very much. So I wrote the part on Zambia, and it was a wonderful experience. It gave me an opportunity to understand how the international human rights treaties under the UN impact the domestic legal sphere. So to start with, to just give a context of Zambia in terms of how it interacts with the international human rights system. So Zambia is a dualist state. So basically, international treaties do not apply directly. So they have to be domesticated. That said, there have been instances when the courts have relied on either the treaties themselves or general jurisprudence from the treaty bodies to make a decision, even where the actual treaty has not been domestic or directly domesticated by the state. And by way of introduction also, although there are several precedents which mention international law or rely on some aspects of international human rights jurisprudence, there are at least 5 legal instruments in the country that directly purport to domesticate or indirectly do so aspects of international treaty law. So these include the Bill of Rights contained in the Constitution, which basically builds up on the Universal Declaration of Human Rights. We have the Children's Code, which was enacted in 2022, which mirrors the CRC. We have the Persons with Disabilities Act, which mirrors the UN Convention on the Rights of Persons with Disabilities. We have also the Gender Equity and Equality Act, which tries to mirror CEDAW. And finally, we have the Mental Health Act, which is also trying to mirror international standards on human rights. So basically, in outline, this is a framework that appears or is designed to align domestic law with international human rights treaties under the UN. So in terms of actual impact on at domestic level, the starting point, I think, is the formal acceptance of treaties. So how many of the 9 core treaties has Zambia ratified or is a state party to? So in the context of Zambia, we have ratified 8 of the 9 principal human rights treaties of the UN. So the only one Zambia is not a state party to is the International Convention on the Protection of the Rights of all Migrant Workers and the members of their families. So this is the only of those treaties the country has not ratified for some unclear reason. And then when it comes to actual incorporation, As I have already indicated, there are 5 treaties, 5 local pieces of legislation that direct or indirectly purport to domesticate those treaties. But when you look closely at them, there are only 3 that are substantially domesticated. So these are SEDO, CRC, and CRPD. So these are expressly mentioned in domestic legislation, and to varying degrees, their standards are imported into domestic legislation. So based on this, then a Zambian can go to court to litigate on the basis that those international standards have been incorporated in domestic law. Also, in terms of awareness, I think you see the same trend. So basically, those treaties that have been incorporated seem to be better known among citizens. So it's difficult to gauge awareness without a survey, but then through the interviews we had, and also looking through newspapers, and also the amount of reliance civil society places on them, the most treaties civil society tends to rely on the CRC. There seems to be so much interest in children's rights. SEDO, I think there's a general trend to promote women's rights. CRPD, and also to some extent the Universal Declaration of Human Rights. The Treaty on Civil and Political Rights, it tends to interest in it tends to go up and down depending on the political context. So when we get a regime that is a bit more repressive, interest around it tends to go up. But when things tend to be a bit normal, and there's a bit of stability in the country, I think interest tends to wane, and people tend to rely on domestic legislation to ventilate their concerns. The other area of impact we could look at is how courts, to what extent courts rely on international human rights standards, or as embedded in the treaties. We have a number of cases that have been resolved based on provisions of international human rights treaties. These are either direct provisions or treaties, or general jurisprudence or principles arising from treaty bodies. So one example is a case decided by the Supreme Court in 2019, at the end of 2019, 2 prisoners who were HIV positive and were not given appropriate diet in prison went to the courts to argue that their right to life was violated because of their medical condition. They might die if you are not given the appropriate diet. So the significance of this is that in our context, our constitution does not recognize social and economic rights. So they had to weave and embed their claim around right to life. So initially, the High Court rejected their application on account that Zambia does not have socio-economic rights. But the Supreme Court reversed that decision and held that by not providing appropriate food and appropriate healthcare, that inevitably had a consequence on the quality of life they're going to live. And therefore, the Supreme Court borrowed from international human rights law jurisprudence around interconnectedness of human rights. So we can see from that angle that there's some impact of international treaty standards in the domestic sphere. So it's not always that positive. I think there have been instances where courts have not done a remarkable job, but there are also good precedents where the courts have actually given voice to international human rights standards. There was also a recent case in last year. The High Court came to the aid of students at the University of Zambia. There was a problem of over-enrollment, and students wouldn't find sitting space in classrooms and kind of stuff. So the court made a decision that that was a violation of children's rights, and borrowed heavily from principles of the CRC around best interests of the child and that kind of stuff, the right to education. Yeah. In terms of use by NGOs, I think the trend is the same. The thematic treaties that have thematic areas where CSOs are interested in, such as CRC, CRPD, and CEDO, tend to be heavily relied on by civil society organizations. In terms of challenges, one challenge I note is that the popularity and impact of UN human rights treaty law domestically is heavily dependent on the political contexts and also the thematic interests of civil society organizations. So where civil society organizations have thematic interests, such as CRC, those tend to have relatively better results than other treaties where there's no one mobilizing around. The other challenge is the implementation of treaty bodies basically is determined by, decisions of treaty bodies is basically determined by the interplay of the way structures and domestic politics play out. So in relation to some orders, for example, from treaty bodies around compensation, I think those have been relatively easy to implement. But there have been challenges where the issue which is brought to a treaty body was after, for example, the Supreme Court domestically had made a final decision. So it becomes difficult to undo that decision. So usually these have worked in a way to push the government to relook at certain policies and also to find administrative remedies. There have been instances where the decisions have caused at least good or positive debate in the country. For example, the issue of death penalty. And I would actually attribute the recent decision to abolish it to the impact of the continuing dialogue between international human rights standards and the need to implement them domestically. And the final challenge I note is, although we have had positive jurisprudence in some cases from the courts, but I think to some extent we still have a problem of judges who might have limited understanding of human rights. I think there's need for continuing training of adjudicators in the field. I think we had 2 or 3 years ago an interesting case of deaf people who went to seek the intervention of the court because the law on driving licenses does not allow them to drive a vehicle, to obtain a license. But for some reason, the High Court said, if we allowed them, there would be a danger on the road to everyone, so they shouldn't be allowed to drive. But then when you look at trends around the world, I think the decision of the court doesn't make sense. So in outline, these are the impacts I note and also some of the challenges. Thank you very much.
Okay, thank you so much, O'Brien. And just on time, I was just about to chime in there. But I think some of your observations are really illuminating. Of course, we're hearing that Zambia is a country that has ratified a number of instruments, which is a positive thing. There has been some level of domestication, perhaps a bit patchy. There's jurisprudence that draws on the international human rights system, which is a positive thing. But the point that you're raising around the impact being dependent on the political context and the thematic interest that some civil societies have, and not least the limited knowledge by adjudicators. I think these are really all important points. And as I know that that your time is a bit limited, I just wanted to check in. I think we have a couple of questions in the chat to you, and perhaps you can answer those before then I move to the next speaker. I have my colleague Lindy Kay, who's going to be helping to read out some of the questions. Lindy Kay.
Good day all. Thank you for the floor. So the first question, O'Brien, is I think we're getting a sense of people wondering where's the conflict between domestic law and international law? That's the first question. And then the second question was in relation to the CRC. And the question was, you mentioned that there was domestication to varying degrees, and they wanted you to speak a little bit on how we can close the gaps in terms of domestication. So those are the two questions, if you could please. Thank you.
Thanks very much. So in relation to the conflict, if there's conflict between domestic and international standards, yeah, there have been instances where in some areas there's strong resistance. In areas, for example, which implicate certain beliefs of the people. Initially, for example, when the movement around women's rights started, I think there was strong resistance. But I think over time, this has reduced. There's relatively good energy to improve the lot of women in public life and also in other spheres of life. In other areas of other areas like the issue of LGBT, I think it is still relatively sensitive for political and religious reasons. But at the same time, I think there's some improvement. I think 2 months ago, I was on national TV arguing for the rights of the LGBT community. So that wouldn't have happened 10, 20 years ago. I could have been lynched. So while there's resistance, but also I think there's an indication that slowly things are improving, and the gap is closing in areas where there are potential areas of conflict. On closing the gap between CRC and to what extent we could go flat out to implement. Yeah, so we still have concerns. So we in 2022 we as a country passed a new children's code, which largely incorporates all the principles of the CRC. But there's strong resistance on certain areas, especially in dealing with children who commit crimes. There's now a strong feeling that the country probably went too far because the country is not prepared for some of, some people feel that we are treating crime softly. There have been, I think, 2 or 3 cases, homicides and aggravated robberies involving children, and the court seems, or at least that is the recent interpretation of the Court of Appeal, that you cannot jail or send a child to court, no matter how, to jail, no matter how bad the crime they committed. So there seems to be a new resistance now trying to walk back from some of the relative progressive provisions in the Children's Court that try to implement the CRC. So what I foresee happening in the next few months or few years is that the people who are a bit conservative might force the government to walk back on some of the relatively progressive changes on children's rights. Actually, the Court of Appeal itself, in a recent decision passed in a few weeks ago, is urging government to amend the Children's Code, saying that it limits sentencing capacity of the courts where children commit very serious offenses, because they cannot send such children to prison now. So they have to find other alternative ways of dealing with them, which alternatives don't seem to be well supported in terms of available infrastructure in the legal system. Thank you.
Okay, O'Brien, there's a lot of interest in your presentation, but unfortunately we are running a bit behind on time. But perhaps I can just come back to you on one specific point that you raise, and somebody's also asking the question around the role that civil society can play to advocate to have a certain number of judges in court to have a human rights background. If you can maybe pick up in, a couple of lines on that one, and then I will move to the next panelists to be able to present on their countries as well. O'Brien?
Yeah, thanks very much. I think this is an interesting question. We have a constitutional court which requires that judges should have specialized training in other constitutional or human rights law. But then that court does not have jurisdiction over the Bill of Rights, largely because of how we went about amending the Constitution in 2016, because our Bill of Rights was not amended and the jurisdiction clause remained in that unamended Bill of Rights, and therefore jurisdiction still falls to the High Court. And the High Court is basically general judges. They are not required to have specialized training. So that creates a problem, because it would become difficult to specify that a High Court judge should have human rights specialization when the court was created for a general purpose. Probably the way around it to have a specialized division within that High Court that would handle human rights cases. But for now, we don't have that specialized division, yes.
Okay, so a specialized division. But anyway, thank you so much, O'Brien, for those insights. Please do have a look at some of the comments in the chat. Maybe you can respond to them before you go, or otherwise, if there's another opportunity to do so. But I would like to now move to the next panelist.
Thank you very much.
You're welcome. You're welcome. Who is Mustafa Kamal Al-Said, who is a professor of political science, the Faculty of Economics and Political Science in Cairo University. He has also taught at American University in Cairo, Harvard, and Colgate University. He is a visiting scholar at UCLA and a research associate at Carnegie Endowment for International Peace. He has published in English, French, and Arabic on issues related to civil society, human rights, and the politics of development in Arab countries. Mustafa, it's a great honor to have you. The floor is yours.
Thank you very much. I am quite thankful for this opportunity to give some of the findings of my chapter. Egypt has ratified 8 of the 9 core treaties of the United Nations human rights system. However, it is very important to note that the lag between signing a convention and ratifying it was quite long. Egypt has ratified the treaty on the elimination of all forms of racial discrimination, has adhered to the 2 covenants on civil and political rights and on economic, social, and cultural rights, but in 1966, but these were ratified in 1981. So there was a long gap between the signing and adhering to the treaty, and I think this should be explained by the fact that for some time it was believed that human rights are a tool in the hands of superpowers, and they use it against newly independent countries, and therefore the government was quite reluctant to ratify human rights covenants. However, the situation changed in the 1980s with the government adhering to 4 conventions, and the government also was taking a long time to report to UN human rights bodies. It took the government almost decades in order to report to recommendations of the UN Committee on the Convention Against Torture, and the same thing also with respect to the Covenant on Civil and Political Rights. If we look at the impact of these conventions at the domestic level, I would like to make a distinction between those conventions, which I would call them functional conventions. They deal with the rights of specific groups like children, like women, like people with special abilities. or migrant workers, and the government would be quite willing to implement these treaties and would have no problem with them. But when it comes to the Convention Against Torture or the Covenant on Civil and Political Rights, the government would have some problems. And in fact, these were not just a matter of speculation by academics, but there were some observations by UN bodies on the fact that the Egyptian government did not seem to be acting fully in accord with these two conventions. And to a certain extent, there is a certain view within government circles that human rights are to be interpreted according to the culture of each country. So what might be accepted in Western countries might not be compatible with Arab and Islamic culture. There is also this view that when human rights are used by some people in a way that could threaten state security, then state security would have the priority. As a result of this, we find that the level of implementation varies. With respect to those, functional conventions dealing with, rights of children, rights of women, rights of handicapped people, we find that these inspired, in fact, laws. These also led to institutional development. So there is a National Council for the Rights of Women. There is a National Council for Motherhood and Childhood. There is a National Council for people with disabilities. And these councils act on the basis of these conventions. Also, the Convention on the Rights of Migrant Workers has also indirectly influenced the establishment of certain committees within the government who try to, deal with rights of migrant workers. All treaties, in fact, are considered by the Egyptian Constitution to be part of the domestic law. Once these conventions have been ratified and have been approved by the legislature and ratified by the president, then they become part of the domestic law. And this is particularly the case with human rights conventions. The Constitution, has two articles. One, dealing with all treaties that once they are ratified, they become part of domestic law. And another article which emphasizes that human rights treaties, are once they are ratified, they are part of the domestic law. But when we come to the impact of these conventions, first of all, in some cases they gave rise to domestic laws, and I give examples of this: the conventions of the right of the child, or CEDAW, or the Convention on the Rights of People with Disabilities. These gave rise to laws which, in fact, echo or almost copy the conventions. Also, in certain cases, the conventions led to amendments of the domestic law. This was particularly in the case of CEDAW, which called for complete equality of rights between men and women. So there have been amendments of Egyptian law which allowed women married to foreign husbands to pass over their nationality to their kids. So this was an amendment of the law as a result of Egypt signing and ratifying CEDAW. When it comes to the judiciary have been quite reluctant, in fact, have been quite reluctant to accept claims by lawyers referring to human rights treaties. They say that the fact that the Constitution calls for human rights treaties to be part of the domestic law, this is in fact the Constitution is addressing the legislature, not addressing the judges. And for the judges to implement these treaties have to be embodied in domestic laws. I mean, the judges do not go directly to the international treaties, but they would use Egyptian law, which enacts the articles of the international treaties. However, there were few cases in which the judges accepted the international human rights treaties as a remedy. There was one case of a strike organized by railway workers, and the lawyer of the defendants said that in fact, these workers, when they went on strike, in fact, they were, acting according to the Covenant on Economic, Social, and Cultural Rights. And in fact, this was accepted by the judges, and the government opposed this. But when the workers were tried for a second time, the same argument was made that in fact the right to strike is quite compatible with the Egyptian law, because Egypt has ratified the Covenant on Economic, Social, and Cultural Rights. There was another case in which the lawyer defended a young man who was in fact killed by security people, and in the lawyer of the accused said that in fact they were not practicing torture. In fact, it was just harsh, cruel treatment. But the lawyer said that in fact the young man was subject to torture, not just to cruel treatment, and that was accepted. But we don't have many cases of the judges acting upon international treaties of human rights directly, and they claim, when they were interviewed, they claimed that in fact these treaties would be applicable at the domestic level only when they are translated into domestic laws. So this is part of the direct material impact of these laws, and I refer to how they are used by the judges. I referred also to the institutional impact of these treaties, which led to the establishment of 4 national councils. There is a National Council for Human Rights, there is a National Council for the Women's Rights, there is a National Council for Motherhood and Childhood, and there is a National Council for the rights of people with disabilities. So this is the institutional impact. In terms of the impact on civil society, in fact, there is a large number of human rights organizations in Egypt, and they cover almost all domains of human rights. So there are NGOs dealing with human rights in general. There are human rights organizations which deal with economic and social rights. There are many centers which defend women's rights. There is one NGO which deals with the rights of prisoners and judges. So there is a good variety of human rights organizations. The impact, the awareness of the human rights treaties, I did examine newspapers in order to find out to what extent they cover human rights issues. In fact, the CAT, the Convention Against Torture, was well covered, also was mentioned in newspapers. The same thing also with respect to the Covenant on Civil and Political Rights. But in fact, they were mentioned because they were issues of dispute between the government and UN human rights organizations. The government was claimed by the Human Rights Council, by the Committee on Torture, of having violated these rights. And this gave rise to a debate in newspapers whether Egypt was really violating these conventions or not. And there were, a variety of views. So these were covered in the media. So, and the media also covers issues of human rights when human rights bodies in the UN report on violations of these rights by countries on which Egypt is not on good terms. So, in fact,
Prof, if I could ask you maybe to wrap up, because we are running beyond the 10 minutes,
right.
But very illuminating.
Yes, my final point is about the challenges. Well, there are, I think 3 types of challenges. First of all, the attitude of the government on issues of human rights, as I said, and this was in fact the president saying that, well, there are standards of human rights, and the standards vary from one country to the other. So Egypt should not be judged by the standards of, Western countries. So, however, this does not lead the Egyptian government to withdraw from any of human rights treaties. But there's this view that certain types of human rights could be respected in advanced countries, but they cannot be implemented or respected in developing countries. The second challenge is, we call it, the first one, I would call it, status, the statist attitude towards human rights, that the state interests have the priority. The second problem is, cultural one. And I think this is quite important, particularly in the case of women's rights. Egypt had put reservations on certain, I think on the Covenant on Civil and Political Rights on CEDAW, saying that, these would be applicable in Egypt and so long as they they are not in clash with the Islamic Sharia. So this is another issue, and this gave rise to, in fact, the negotiations, debates between, the UN Commissioner for Human Rights and the Egyptian government about, what extent, the Islamic Sharia should be, to what extent Egypt should have reservation on basic principles of human rights, based on Islamic Sharia. The third issue is the, economic and social situation in the country, particularly with respect to the Covenant on Economic and Social Rights. Well, it is accepted, it's ratified, but to what extent it is reflected in practice, I think perhaps, I don't know, the resources of the country, the economic policies of the country might constitute an obstacle against the full implementation of the articles of this covenant. Okay, I stop here.
Okay, thank you so much, Prof. And perhaps in the interest of time, I'm going to allow all the panelists to speak, and then we'll take questions at the end. But there are a number of questions that have already popped up. But I think what's very interesting is what you're highlighting is compared to the Zambia example that we heard, that of course it's a very different legal tradition, in terms of Zambia being a dualist legal tradition, and the case of Egypt being quite different. But still, we have a high level of ratification. But there is this difference between the specific groups versus the civil and political rights and other areas, specific thematic areas. But I think what's interesting also is that how the judiciary themselves have interpreted these standards and how they've applied them as well, despite the fact that you have these constitutional elements that provide for invoking these international human rights standards. So I wish to really thank you, Prof, for highlighting those issues. And I will now move to the next panelist. And like I said, we will take questions and comments, and you'll be given an opportunity to respond when everybody has spoken. But the next panelist that I would like to call up is to speak on the case study of South Africa. And for that, I would like to call on Folusho. Is he in the room? Adewale. Folusho Adewale.
Yes, Abigail, I'm in the room.
Okay, wonderful, Folusho. And just to introduce Folusho to everybody, Folusho is a doctoral researcher at the Center for Human Rights at the University of Pretoria and a co-manager of its litigation and implementation unit. He holds an LLM degree from the University of Ibadan as well. And as you can tell, he's also writes a lot on human rights issues. So Folusho, we're really, really grateful that you're with us today. I'll give you your 8 to 10 minutes. Over to you.
Thank you very much for the kind introduction, Abigail, and good day to everyone. It's an honor to present, to briefly, I assume, within 8 to 10 minutes, present our findings on the chapter on the domestic, the impact of the UN treaties in South Africa. This book chapter was co-authored by myself and Tess Mitchell. So briefly, in the interest of time, I would just quickly give a brief background of South Africa's engagement with the UN human rights treaties. So South Africa has ratified 7 out of the 9 core UN human rights treaties. And the 2 treaties that South Africa has not ratified is the Covenant on the Right of Migrant Workers and the Covenant on Convention on Enforced Disappearances. South Africa has ratified the CRC, the CEDAW, the Convention on Elimination of Racial Discrimination, and the Covenant on Civil and Political Rights, the Convention Against Torture, the Convention on the Rights of Persons with Disability, and Convention on Economic and Social Cultural Rights. In terms of substantive optional protocol of the UN, South Africa has ratified all of the 4 substantive optional protocol. And out of the 7 substantive core treaties that South Africa has ratified, South Africa has accepted the individual complaint of 5 of these UN treaty bodies, and the 2 that South Africa has not accepted is the individual complaint jurisdiction of the Committee on Economic and Social Cultural Rights and the Committee on the Rights of the Child. I would then proceed to our findings as it relates to the impact of the UN treaties on laws and policies and decision. The finding shows that there is a considerable impact of the UN treaties on laws in South Africa. And of particular notice, the Constitution. The UN treaties did play a significant role during the drafting process of the Constitution. Our finding shows that the Convention on Elimination of Racial Discrimination, the Covenant on Civil and Political Rights, and the Covenant on Economic and Social Cultural Rights were used by different stakeholders during the negotiation and drafting of the South African Constitution. And in addition to the Constitution, there is quite a lot of laws that have also been influenced, that we find the influence of the UN treaty bodies. And this is predominantly in the form of express reference to these treaties in the preambles of this law. Some of this law notably include the prohibition of hate speech, the Promotion of Equality and Prevention of Unfair Discrimination Act, and the Prevention and Combating of Hate Crimes and Hate Speech. They all made reference to the Covenant on Elimination of Racial Discrimination. And also the CEDAW was also explicitly referenced in the preamble to the Domestic Violence Act. The Convention on the Right of the Child, there is quite a lot of references to this treaty as well in laws like the amendment to the Child Care Act, the Children's Care Act of 2005, and the Child Justice Act. Like I said, there is quite a plethora of laws that I've referred to these treaties. And also with policies, it's also the same. The National Action Plan to Combat Racism and Racial Discrimination made references to both the Covenant on Elimination of Racial Discrimination and the Covenant on Civil and Political Rights. And there is also a lot of policies that have made reference to the Covenant on Economic and Social Cultural Rights and the Convention on the Right of the Child, as well as the Convention Against Torture. It is quite a lot. So there is generally an overwhelming abundance of influence of these treaties on laws and policies. Now, with respect to the judiciary, of course, South Africa is a dualist country by virtue of Section 2314 of the Constitution. But interestingly, Section 39 of the Constitution requires South African courts to consider international law as a tool for interpreting Bill of Rights. And by virtue of that provision, I think what we find is that there is also a lot of references to the UN human rights treaties by the South African court. And they are mostly, however, used as tools for interpreting the Bill of Rights, and they are used to complement existing national laws. However, there are a couple of cases where we did find very strong reliance on the UN human rights treaty system, which we can say that the court did go beyond just using the treaties as interpretive tool. One of them is the case of Sonke Gender Justice versus the President of the Republic of South Africa, where in this case, the court actually relied on the optional protocol of the Convention Against Torture and ruled that the Judicial Inspectorate for Correctional Services in South Africa does not have sufficient independence that would allow South Africa to comply with its obligation under the optional protocol. And there are also three other cases like Kosa Mpeno versus Minister of Defense, YG versus the state, and also Equal Education and Others versus Minister of Basic Education and Others, where the court actually made reference to the state reporting process and the concluding observations of the UN treaty bodies, as well as the state report submitted by South Africa to defend its, guide its reasoning in its decision. So those are very strong influences beyond a mere interpretative role. With regards to individual communications of the UN treaty system, there is very minimal influence. There is only 2 communications, and there is a low level of engagement with the individual complaints mechanism. And our findings shows that stakeholders, particularly CSOs, generally have confidence in the robust domestic judicial system in South Africa. And I would just quickly move to the factors that we found that influences the impact of the treaties in South Africa. So some of the positive factor, of course, is the domestic mobilization around the treaties by civil society organizations and national human rights institutions in South Africa. As explained in the example of the cases that I gave, there is a clear strategic use of the UN treaty system, particularly the state reporting process and the concluding observations by CSOs in some of these cases, and that's why the court relied on some of the concluding observations. So that's one of the positive factors that influence the UN treaty system. Another one is the historical relevance of certain treaties. So our finding shows that the Convention on the Right of the Child and the CEDAW treaty are the 2 most influential. And one of the reasons for the influence of the CRC, of course, in addition to the fact that children's rights are generally popular in most countries, is the fact that there is a bit of historical sentiment towards children's rights issue. In 1994, when the National Children's Rights Committee delivered the National Program of Action to then Nelson Mandela, they had really emphasized on children's rights, and also the Convention on the Rights of the Child, of course, was the first treaty that South Africa ratified. Then the other factor is the international reputation. We did find that South Africa has ratified some of these treaties also because of its concern about its international reputation. Now, the negative factors that affect the influence of the UN treaty, the first one is the perception of treaty bodies and the system by officials in South Africa. There is this general perception that the international system do not understand the peculiarities of the South African system. And one of the evidence of this is the lack of cooperation in one of the cases in which South Africa was found to be in violation in Bradley Macaulay. And the Minister of Justice and Correctional Services did state that the treaty members of the UN treaty bodies do not understand the peculiarities of South Africa, and that's why they did not cooperate with the Human Rights Committee on that case. The other challenge is issues of bureaucratic and capacity issues amongst the lead departments, which has also led to lack of coordination, particularly with regards to engagement with the state reporting process. And the final one that I will just quickly mention is the fact that we also realize that with some of the, between the government departments, there's a disparity in engagement with the treaty bodies, why some departments, like the DSD and the Department of Women and Children and Persons with Disability, are more positively inclined to the international system. Departments like the Department of Home Affairs seems to be less receptive of international supervisory bodies. I will just quickly conclude by just saying one or two things about the trends that we observed between 1999 and 2019, because it's a 20-year study from the previous study. So of course, one of the things is the CRC and the CEDAW committee still remains the most influential treaties as it was found in the 1999 study. But however, there has been an increase in engagement by NGOs with the UN treaty bodies. And I think one outstanding difference is the fact that the new treaty body members that South Africa has between after the 1999 study are more proactive at the national level and this has led to increased visibility of the UN treaties in South Africa. Thank you.
Thank you so much, Felusha, for highlighting that. And I think, again, you know, it's interesting to see that there are some parallels between some of the countries and very distinct features in others. Again, South Africa, a dualist legal system, highly ratified. Perhaps I will just indicate that perhaps since the book was issued, South Africa has actually ratified the Convention now on Enforced Disappearances. We were very glad to receive the news last week that they have now ratified this instrument. So they now have just the one on CMW on migrant workers that is pending. But having said that, I think, you know, I think what you're highlighting here is how, you know, in the South African context, they have really pulled from the International Human Rights Treaty system in terms of taking inspiration in its own constitution, and how the courts, despite being a dualist country, have actually used international law as part of its interpretive jurisprudence. Again, pointing to CEDAW and CRC perhaps being quite influential in this country context. And I think that's an interesting trend that we're beginning to see in all of the three countries that we have looked at so far. But there's a lot there to unpack. And of course, I would encourage all participants to post their questions in the chat box. I am going to now try to turn to the last panel speaker, and then we will open it up for questions and comments and further engagement. But let me just check, is Ibrahima Khan in the room? No, perhaps he's not able to connect. So Prof. Viljoen, would you be willing to give a couple of highlights maybe on Senegal as a country example, just to wrap up our discussion and make sure we cover all of the countries on the continent? Thank you.
Thank you very much. I'm sure that, you know, Ibrahima was just somehow unable to join. About Senegal, I think Senegal is, you know, we heard 7 and 8 ratifications by other states. Senegal has a full house. It is the best pupil in terms of formal recognition of the treaties. It has ratified all 9 treaties and also all other optional protocols. Only one outstanding is the second optional protocol on the abolition of the death penalty, which for political reasons has not been ratified. I think when we look at Senegal, it is important that it really has a very strong tradition of being a model in terms of rule of law. In West Africa, it is a rare case of a country that has not undergone a coup d'etat. And in a sense, we see the direction of human rights observance somehow focused on the multilateral aspect of it, sometimes more so than the internal aspect. We can also see that there has been an acceptance of the complaints mechanisms. 4 of the possible complaints mechanisms had been accepted. So it is also quite high in terms of an African audience. It is a monist state, you know, in terms of its relationship between international and national law. In the previous 20 years, in terms of trends, the conclusion was that there had been a significant impact, particularly because of the political alignment at the time, the Convention Against Torture, CEDAW, and CCPR had all had very important influences on the evolution of Senegal. But if we now look at the last 20 years, the author concludes that there has been some form of stagnation, that in a sense we have seen perhaps not regression, but a certain lack of energy and exposure to those treaties, where there has been more of influence that is kind of innovative and renewed, has been in respect of the new treaties that had been ratified in the last period. So the fact that they were novel ratifications seemed to have energized civil society in ways that were quite telling. And the two that are in particularly pointed to in the chapter would be the Convention on Migrant Workers and on the persons with disabilities. And I'll just maybe look at two very clear examples of the impact. You know, Abigail and audience, that in terms of the study, the closest, the most exemplary form of impact would be when there is a concluding observation or review of a treaty body, and one can see in a very marked way the influence of that, for example, recommendation on the changes to domestic practice. And we have that with migrant workers, because in 2016, the treaty body, in a concluding observation, called on Senegal to make sure that migrants from Senegal who are outside in the diaspora would be entitled to vote in parliamentary and presidential elections. And then we see in 2017 the adoption of a law that actually enlarges the parliament and designates a number of parliamentarians for the diaspora. The other kind of concrete and direct example would be for the Convention on Persons with Disabilities, where we see that in 2009, Senegal ratifies, and in 2010, we see the adoption of national legislation that uses the definition of a person with disability almost verbatim in the national legislation adopted at the time, and to a large extent really brings in a total new legal regime in terms of persons with disabilities. If we look at the individual complaints mechanism, Senegal has accepted 4 of those. Just like in other African countries, there has been a minimal effect, very, very few cases, very few communications. That's a recurring trend across the continent. Only 3 cases, and those have been heard by the Human Rights Committee. Interestingly enough, in 2 of them at least, we see that Senegal actually implements the views expressed, but in one much more political case, a case that was more contentious, there is some resistance. In fact, when Senegal reported, the director of human rights of Senegal at the time committed Senegal to the implementation of this decision. But when the director of human rights came back to Senegal, he actually lost his job, because what he set out the position to be before the treaty body was at odds with how the government saw it. And that shows the kinds of resistance, also maybe internal contestation about these views. On the role of the judiciary, very briefly, although it is a monist state, we see quite a very limited influence through the judiciary. And the author again shows perhaps the reasons being the role of the judiciary in civil law societies, where judges often find their way into senior positions because of a career path. They are civil servants, and that certainly links them in a particular way to the executive. And also in general terms, there is a very strong hold by the executive over the judiciary in Senegal. So those factors had limited and constrained the influence of the treaties in the jurisprudence. And lastly, I think just as in many of the African chapters, the role of the broader context as a constraint to the potential impact of the treaties and the treaty body recommendations is underlined in Senegal. And the author does this with respect to the so-called Taliban children who are begging on the streets of Dakar and other cities. Those are children who also attend the Dara schools that are linked to religious observance. So many treaty bodies had given recommendations around the abolition, the implementation of laws that exist, the realization of the rights of these children. But the resistances, the author maintains, are really threefold. The resistance to the implementation, the impact of these treaty body recommendations would be the hold that culture and religion has, the deep-seated nature of the underlying, practice, and how difficult it is to unseat these practices. The author really makes a kind of a plea for greater comprehension and understanding of how complex these issues may be. This second factor is also how this cultural and religious understandings have been politicized. It shows the political hold that leaders within the Muslim societies have in Senegal that led to even attempts at legislation being reversed in order to placate or to accommodate these views. And the last is also the lack of an administrative structure, lack of bureaucratic framework to ensure the effective implementation of laws, because there are actually regulations against child begging on the streets already in the statute books. And that clearly links also back to resource allocation and resource constraints. So the bigger picture being underlined as a constraint to the full implementation of treaties of the UN in Senegal. Thank you, Abigail.
Thank you so much, Prof. Yes, again, really interesting highlights there. And I think, as you mentioned, Senegal comes up tops in terms of the numbers of treaties that it has ratified, that it comes from a strong tradition of the rule of law. And I think that's something that you emphasize quite well. And how, there were these novel treaties that they ratified that had a strong influence in the early days, perhaps a bit of stagnation since then. But the exposure and whatnot continues to have great influence, in particular for the new treaties that have been ratified. And you spoke quite well to the examples of migrant workers and disabilities and how concluding observations have actually been used. And I think those highlights are really also important. So I think what we have, dear participants, is, the examples that we have illustrated today that point to, similarities, some differences in some areas, but clearly some impact. I think it's worth underscoring. So I'd like to now turn to the question and answer session and ask Lindy Kay to perhaps pick up on a couple of questions that have been posed, which I can then take back to the panelists.
Thank you, Abigail. So we have 3 questions. There are 2 questions from Mustafa. Mustafa, you've been asked whether the government has a position on FGM. And then the second question is there mechanisms in place for training for judicial officers in terms of international human rights law and principles? And then there's a general question which pegs to whether the African Charter on how does the African Charter on Human Rights relate to the UN human rights treaties and conventions? So those are the 3 questions we have for now. Thank you.
Thank you very much for all these questions. On FGM, the government has a clear stand on this. It is banned in Egypt, and there is a law on this. And I think medical doctors who are accused of acting against this, are tried. So this is the problem is more of the culture rather than the law or the action of the government. So I think no, the government is against these practices. I did participate myself in a workshop of training of judges on issues of human rights. Judges are supposed to know about human rights because they are graduates of faculties of law, and all faculties of law in Egypt do teach human rights. how they relate to, the Constitution, and this is also part of their studies of international law. So as graduates of law, they are supposed to know about human rights, but also, I did participate once, and in fact, I was I was asked to evaluate the training of judges and police officers on issues of human rights. So that was a deliberate effort, and I think this was supported by the United Nations, but that took place, I don't know, long time ago. I have no information whether, this kind of special training does take place, but as I said, judges would claim that they would implement, international human rights treaties once they are translated into Egyptian laws. I would like, on this issue, I would like also to add something that, even though the Constitution considers international treaties and particularly human rights treaties to be part of the domestic law, however, they are not implemented by themselves. They require laws, to spell out how they would be implemented. So, for example, the right freedom of association, of course, is called for in the Covenant on Civil and Political Rights and on the Covenant on Economic and Social and Cultural Rights. But how to exercise the right to association, this would require a law. So what happens is that for some of these treaties, the corresponding law does in fact, put conditions for the exercise of freedom, for the exercise of these rights. And this in fact gave rise to a controversy about the law of freedom of the law of association in Egypt. It was criticized by many organizations, many NGOs, not only human rights organizations, and in fact also criticized by aid donors. And this led the government in one case to introduce a law which further restricted the right to association. And as there was a sort of an outcry by human rights organizations and by aid donors, so the government had to revise this law. And the same thing would apply to labor laws. Also, they would restrict some of the rights which are included in the Covenant on Economic and Social and Cultural Rights, and also in labor conventions which have been signed and ratified by the Egyptian government. So I think this is also another obstacle, to what extent the domestic legislation is really in harmony with the treaties which are supposed to be part of the domestic law. On the third question, I think Egypt has ratified the African Charter of People Human Rights, and also is part of the legal system associated with the African Charter. And I don't think there is any incompatibility between the African Charter and human rights treaties, but I think the African Charter does emphasize certain rights, does condemn racism, apartheid, much more than it does specify, certain practices which are not in harmony with human rights, more than this comes in the UN Human Rights Convention.
Thank you so much, Prof. And I just wanted to check if anybody else or other panelists wanted to respond to the question on the link between the African system and the UN system from their perspectives.
Yeah, maybe I could just say something, but okay, I see Prof. Frans wants to say something, but I'll just quickly say that, I mean, in terms of the link, of course, clearly the some of the link between the African Charter and the UN Human Rights Treaties, I think the most connected one for starters would be the fact that the protocol to the African Charter on the protection of the rights of women in Africa, which addresses women's rights, there is some correlation between that protocol and the Convention on the Elimination of Discrimination Against Women. And we've seen instances of cross-references between the CEDAW Committee and the African Commission on Women and People's Rights, the body that monitors that protocol. And also the Charter, of course, to protect civil and political rights, which also resonate with some of the rights in the Covenant on Civil and Political Rights, and also the same thing for economic and social cultural rights. But I think a common trend is also that there seems to be more engagement, broadly speaking, with the UN human rights system when one compare that with the engagement with the African human rights system. And of course, within the context of South Africa, that is something that was also seen, but it's not just peculiar to South Africa. It's something that is common amongst most African states. Thank you.
Maybe then, Abigail, to just add to that, yes, I agree with you, Felusho. In terms of the regional system generally, if we look at the study as a whole, in the Inter-American region and in the European region, we see that the regional systems in many ways almost eclipsed the UN system, that there was much more awareness, interest, and also salience of the regional system in important areas. That is not the case in Africa. In general, we see that there is a lesser awareness, a lesser acute reaching out to the African regional system. I think that the one added element there is that in terms of complaints, however, the African system, the African Charter, allows immediate automatic complaints to the African Commission, whereas in the UN system, one needs to accept these. So a country like Egypt, for example, which has not accepted any of the UN complaints mechanisms, we've seen quite a number of complaints being submitted to the African Commission on Human People's Rights in recent times. So there is an avenue where the African regional system, I think, can be more fully explored. Thanks.
And I think what you're raising there, Prof, is the importance of this complementarity. You have the national, the regional, and the international system, and that's really interesting. And the example that you're showing there is demonstrating the importance of that complementarity. I just want to check if anybody has any questions. You could also raise your hand. I'm not seeing Lindy Kay. Are there any further questions that I perhaps missed?
No, there are no questions. There
are no further questions. Okay.
Yeah.
Okay. I'm seeing. Oh, Prof. Mustafa, did you want to come in?
Yes, please. I would like just to say something, philosophical about the African Charter and the UN human rights treaties. I think the notion of, people's rights, I think this comes strongly in the African Charter, whereas it is, quite problematic in the UN human rights system. Of course, there is, this question of defining people and minorities, to what extent, would a certain minority become people? But I think this is not very clear in the UN human rights treaty. Of course, there is the people's right to self-determination, people's right to peace, people's right to safe, environment. But the notion of people's rights, I think the African Charter advanced this notion, and this is, very good. And this is, one specific feature of the African Charter. Also, the question of, rights of groups that, I think the UN human rights treaties emphasize, individual rights, but, group rights, come very strong, more than group rights, but group rights come very strongly in the African Charter. So I would like just to point out to these philosophical differences between the African conception of human rights and the conception of human rights as it comes in the, different UN human rights treaties.
Thank you so much, Prof. And perhaps that is another book, right? But I just really would love to thank all the panelists for really illuminating us this morning on 4 really important case studies that speak to different contexts, very interesting, but lots to learn from each of one. In order maybe to close, because we do have just only 4 minutes left, I'm just seeing the time has already escaped us. I would like to give each panelist perhaps 1 minute. If you could say, in one line, what your key takeaway would be from the work, the study that you did. What is it that we need to carry through to ensure, because in the end of the day, what we are trying to get to here is impact, the relevance of this system. What would be your one takeaway for all the participants to consider as we try to wrap up the webinar? And then I will hand it over to you, Prof. Viljoen, to sort of close it and also give your key takeaway as well. But I'm seeing Prof. Mustafa, can I call on you to start? And then I will also ask the other panelists as well.
Yes, I think it is really very important to engage in a dialogue with governments to emphasize that this notion of the cultural relativity of human rights does not really apply, because in fact, if we examine all cultures, we'll find that there are common elements which give rise to a universal concept of human rights. Because this argument that what is good in France or in Germany might not be good in Egypt or Libya. I think this is an argument which is used by governments, and I don't know how successful we would be in talking to the government that in fact human rights are universal rights, and they are not subject to these cultural explanations, which are in fact politicizing culture in order to promote authoritarian policies. So I think this is one of the issues which come out of many individual chapters, and it should be emphasized.
Thank you. Felusho, what's your takeaway? What would you like to leave us with?
Thank you, Abigail. What I would like to leave us with is the fact that it is important for us to see the international human rights system, broadly speaking, and of course, specifically the UN human rights system, to see the cup as half full as opposed to half empty. And what this study has shown is that despite what might have been said about the inefficiency of the system, there are definitely evidence of positive impact of the system. And for us, as every one of us here, I believe we are all stakeholders of the system. We are the biggest channel of influence for the system as domestic actors. And it is important for every one of us through strategic means and innovative approaches to utilize and continue to utilize the system at the national level. Thank you.
Thank you so much, Felusho. And Prof. Viljoen, what is your takeaway and how would you like us to conclude today?
Yes, thank you very much, Abigail. Thank you, Felusho. I think I can just echo in a way what Felusho said. I think what we saw also in the last 20 years, even at the UN level, there's a much greater awareness that things cannot be made to change from Geneva and in Geneva. The change needs to happen at the domestic level through building alliances and strengthening national compliance constituencies. Different actors who are interested in, energized by the UN human rights system. I think that is the refrain, in a sense, that goes through all the studies in the book also, is the emphasis that ultimately we need to develop national institutions and national ways of being receptors, if you like, and making the UN system work for us. If I may then just also thank you, Abigail, and all the panelists, everyone who worked together with us on the book. I also echo your words to remember, Christof. The book was and is dedicated to the memory, to the legacy of Christof. That's what the unanimous decision of all the authors had been who had worked with Christof. I think his spirit certainly has been with us today, and I think his soul, soars in the knowledge and the assurance that these matters that have been so important to him are certainly important to everyone who had been participating and that will take this work forward. I just want to emphasize that the book, although I showed you the hard copy here, the very voluminous book, it is open access. It's available on open access. Anyone can just, I'm sure, Google the term. So I really would like you to encourage yourselves to have a look at those chapters that we discussed, and you can see them in more depth. It is free and easily accessible. Abigail, you emphasized, how also this is still a work in progress. We just learned last week that South Africa has ratified another treaty that had not been ratified before. And that is, in a sense, a weakness or a challenge of this work that we've done, because even as we completed it, it becomes outdated. It becomes continuously outdated because we cannot, keep renewing the information. But it's also, in a sense, an opportunity. And we, in the Center for Human Rights, in the memory also of Christof, we are committing ourselves to work with the Office of the High Commissioner for Human Rights on providing a database essentially that will bring the primary texts on which the authors relied together, so that anyone who wants to do further research can see the laws and the cases and so on that had shown these examples of impact. But beyond that, we want to extend the database of primary text, primary examples of impact beyond the 20 countries in the study to include all 193 United Nations member states. And then we would like to see ultimately that the kind of analyses that we have in these chapters, that they would also be then extended. They'll be updated for the 20 countries that are included in the book, but that we will also extend the analysis, working with student groups, clinics, academics, practitioners across the globe, so that there'll be a portal where one could find the primary documents that show impact, but also an ongoing, continuously updated group of authors working on analyzing the impact so that it becomes more accessible. Because I think knowledge, about the state of affairs is an important first step to impact on and change that state of affairs. So with those words, I thank you very much, everyone listening in and contributing, all the authors, also to Rachel Murray, who came on board as the co-editor, and all those involved. So maybe back to you, Abigail, to have the last word.
Thank you so much, Prof. And what I can say is that the Office of the High Commissioner for Human Rights, we stand committed to working with you to continuing this work to determine where the impact lies. And as you said, it's an incredible tribute to Prof. Christof Heyns, who is the pioneer of this book. And we're really grateful to you and Rachel, to all the hard work that you put in completing this masterpiece. The second revised edition. We're very proud of this work, and we are very keen to continue working with you. So maybe if I can conclude on four very, very brief points. Number one, there has been impact, and I think we have to acknowledge that. I think this webinar has emphasized the impact, that it exists, that the treaties matter because they have, resonated at the national level. The third, that the treaties matter, but we still have work to do to enter the hearts and minds of all people everywhere, because that's where we're going to have the most lasting impact. And finally, the work continues, and it's up to all of us to put in the work and to complete this task. So with that, I would like to conclude this webinar on the launch of a publication on the impact of the United Nations human rights treaties at domestic level. I wish to thank all of you for participating, and I wish you a good rest of the day.